Representative Jennings,
Excused.
Representative Nemec,
Here.
Representative Oakley. Here. Representative Provenza. Here. Representative Rodriguez Williams. And Chairman Washington.
Here. Would you confirm we have a quorum?
We have a quorum.
Very good. So our first bill today is Senate File 23. Would the judicial branch witness like to come forward? I'll introduce the bill briefly. This was an interim bill that Joint Judiciary put forward. It has gone through the Senate side and has come to us now for our consideration. The bill is fairly lengthy, but what it accomplishes is fairly straightforward. Many years ago, we created treatment courts, sometimes called drug courts in Wyoming. These drug courts, treatment courts were established within the Wyoming Department of Health. And as such, were supervised, managed within the executive branch in the Department of Health. Before us in Senate File 23 is a proposal that the day-to-day operations of the treatment courts around Wyoming be transferred to the judicial branch. And the primary argument here is that without the treatment court judge, treatment courts pretty much don't function. The judge is integral to the success of treatment courts. And so the judicial branch proposes that the operational oversight of the treatment courts in Wyoming be moved from the Wyoming Department of Health to the judicial branch. It's my understanding that both the Department of Health and the judicial branch want this change to occur. And with that, Ben, why don't you introduce yourself to the committee and tell us a little bit about why the judicial branch is pursuing this.
Mr. Chairman, members of the committee, my name is Ben Birmingham. I serve as Chief Legal Officer of the Wyoming Judicial Branch. I'm certainly happy to be here today with you to discuss this bill. As you heard Chief Justice Fox remark in her State of the Judiciary address at the opening of the session, the judicial branch does support this transfer of treatment courts from the Department of Health to the Wyoming Supreme Court. And I'm here to reemphasize that support and briefly explain why the judicial branch is in favor of this bill. There's a structural reason to make this change. And that reason is that, simply put, at the end of the day, treatment courts are courts, and courts and administration of courts belongs in the judicial branch. Treatment courts are unique among the many courts in our state system. They involve a team of professionals to include treatment court providers who operate under licensure and accreditation by the Department of Health, supervision provided by our partners at the Department of Corrections, prosecutors who seek to enhance public safety and reduce recidivism, defense attorneys who seek to protect the rights of participants, treatment court coordinators who are local government employees who help with the administration of the courts, and then judges who hold participants accountable under the law and who serve as the critical link between criminal justice and treatment. And this team, under the direction and leadership of the judge, works together to reduce substance abuse and related crimes. So while these courts are unique, they do bear the hallmarks of a court, and they do bear the hallmarks of a judicial proceeding. That is adherence to the principles of due process, a formal courtroom setting with judges and robes who hold participants accountable under the law, prosecutors and defense attorneys who work in a more collaborative fashion, but who still advocate for their clients and interests, and then formal court rules and processes that govern the entire proceeding. As we look at treatment courts and how they're handled in other states, most states, nearly all states that have treatment courts, house the courts within their judiciary recognizing that administration of courts belongs in the judicial branch. So that's the structural reason for this change. That's why we support the change. But there's also a strategic benefit, and that is Wyoming, like every other state in the nation, faces a behavioral health crisis. And our judges on the front lines see this crisis every day. They see it in the form of clogged dockets. They see it in the form of this unproductive recycling of individuals through the criminal justice system. But they also see the ability and potential of treatment courts to halt this unproductive recycling. So because our judges see the impacts of this behavioral health crisis, because they see the potential benefits of a treatment court at stopping this unproductive recycling of those with substance abuse issues through the system, our judges are really committed, and our branch is committed to getting the most out of treatment courts. We have requested and received in the current version of the budget bill an appropriation to hire a consultant with expertise in treatment courts to perform a review of Wyoming's treatment courts and to help the judicial branch and our partners come up with some recommendations and ways to make our treatment courts more effective. And we are certainly committed to doing so. So briefly, those right there are the reasons why we support this bill and support this transfer. And I'd be happy to stand for any questions the committee may have.
Thank you, Mr. Birmingham. Any questions for Mr. Birmingham? Representative Chestick?
Thank you, Mr. Chairman, Mr. Birmingham. I am inclined to support this bill. It makes sense to me, but I always, this is a big change, and I want to make sure that we're doing it for the right reasons, and we're not creating any unintended consequences. So I guess I'm curious. I wasn't here in Wyoming when this was created. I was practicing law in Pennsylvania when we created them in Pennsylvania, and they were court related. So that model makes sense to me, of course. But what was the reason why in Wyoming they were put under the jurisdiction of the health department to begin with? My first question. I may have some follow-ups.
Perhaps Mr. Johansson wants to come to the table as well, and Director Johansson might have some history as well. And either or both of you are welcome to field that question.
Mr. Chairman, Representative, I'll take an initial shot at this, and I certainly wasn't here when treatment courts were launched in Wyoming, but my understanding is at the time these were new creations, and we didn't quite know how to handle them because they certainly have judiciary components, but there's also that treatment component. And I'm not sure at the time our understanding of how treatment courts worked. I'm not sure we had the full enough understanding to really recognize that these belong within the judicial branch. But as treatment courts have become established and been around for some 30 years, we've seen nearly all states moved to putting the treatment courts within the judicial branch.
Director Johansson, would you state your name for the record and then answer if you wish.
Thank you, Mr. Chairman, members of the committee. Stephen Johansson, Director for the Wyoming Department of Health. Not much to add, Representative Chestick, to what Mr. Birmingham said. The history is decades old here. I presume in the time these were being established that treatment component was the main issue and kind of the main problem that the state was trying to solve. As you'll see in this bill, there's a number of items where the Department of Health will absolutely remain front and center for these programs in terms of certification and accreditation of the treatment component. And for the committee's edification, the way these programs work is that, as Mr. Birmingham mentioned, is absolutely a court. It's a judicial proceeding. What those local programs do that choose to participate in this area is those courts, those treatment courts, then contract with local providers, mental health and substance use providers. Some of them are providers that we fund in our general community mental health and substance use system. Some are not, are different types of community providers, but all meet Department of Health standards of certification, accreditation, quality, those types of things. So it's kind of a mixed bag to answer the question, but historically, I presume that when the state was looking at this, it was either focusing on that treatment component or, the big behemoth that is the Department of Health. When you try to find somewhere to put a program, sometimes it's easy to put it in the big agency.
For those in the room and those listening online, Senate File 24 was also noticed for today. That notice came out before the speaker told us that he wanted us to gavel in at 9:30 this morning for our general session. So we will probably lay that bill back, Senate File 24, and we'll deal with it on Wednesday. So if anybody's hanging around in the room waiting for Senate File 24, you can depart and get a cup of coffee, and we'll continue with Senate File 23. Any further questions, Representative Chestic?
Yes, Mr. Chairman, a follow-up if I may. So I'm familiar also with juvenile courts. There's other types of specialized courts that are run by the court system, and they tend to leave the when a adjudication is made, the sentence is carried out by some provider, some third party. Sometimes it's a county facility, but oftentimes they rely on outside agencies to enforce or carry out the adjudication. And I guess what I'm concerned about, and this is what I was alluding to earlier about the potential for unintended consequences, a court needs to be detached. It needs to be neutral and objective and stand away from the ultimate consequences. And where I've seen examples of juvenile courts that got in trouble where they developed too close a relationship with a provider, and that gets some people in some pretty deep trouble when that happens. So I guess my concern here, and again, I'm not saying I'm opposed to the bill. I think I'm probably going to vote for it, but I just want to make sure we're doing it for the right reason. Do you see any potential or danger in involving the court too closely with the subsequent treatment programs? And does that create some kind of bias or considerations in the court's mind that might not be appropriate at the adjudicative stage?
Director Johansson.
Chairman Washut, Representative Chesik, it's a great question. Let me try to answer it as best I can. I don't see that concern here in this bill, but that doesn't mean those concerns haven't been present with the operation of these programs and wouldn't be going forward. The way, again, as I mentioned, not every community, not every county participates currently in the treatment court, what we've colloquially referred to as the drug court programs in Wyoming. Not every community participates. The way that I think we check against that type of conflict of interest, for lack of a better term, on certain providers is to have those standards, both on the treatment side, on the accreditation side, and the quality side, which we currently enforce. We basically use kind of national benchmarks to ensure that quality. And secondly, those contracts are often reprocured. And the reason I mention those as checks against is because in Wyoming, we struggle with scale. As everybody here knows. So you have a small community. Often there's not a great choice among providers that would provide the service. The court does its business. The partners that Mr. Birmingham mentioned that are involved do their work on this program, but you need that treatment component, and that needs to be procured. I don't see the potential, because we haven't seen it in at least since I've been here in the last decade or so with that sort of conflict. But we have seen communities move away and move toward other providers because of quality reasons, because of things that they're not meeting standards. And I think those vehicles are still very much here. And as I mentioned before, in partnership with the Judiciary and the Supreme Court, the Department of Health will still be very much involved in ensuring that sort of quality and compliance from those providers. Will likely do that through a memorandum of understanding. And as I'm not sure if you discussed this yet, but the full transition isn't effective until July 1st of 2024. That gives us some time to close out the current biennium, but also transition whose duties are what and memorialize that in an agreement. So again, general way of answering your question, but very specifically, as Mr. Birmingham and the Supreme Court know, my big concern in doing this transition, which we fully support, is to ensure that those types of quality standards, that type of due diligence for the providers is still performed when the transition is made. And I'm comfortable that we have that here.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I guess this question can be for either one of you. I've just had some constituents email me, and I know this has been vetted through the other side already, but I guess interested in what was brought up on the other side as far as constitutionality, if there's any barriers to our state constitution and transferring the powers, et cetera.
Director
Mr.
Johansson.
Chairman, Representative Rodriguez Williams, since I'm not an attorney and don't claim to be, I might kick that over to Mr. Birmingham. From my lay naive opinion, no, I think this is within the powers of the legislature to decide which agency or program best fits in.
Mr. Birmingham.
Chairman Wassett, Representative Rodriguez Williams, I'd certainly agree with Director Johansson. I think the important thing to note here is that the branch isn't providing treatment. The treatment's provided by providers. The branch isn't providing supervision that's provided by the executive branch. The branch is simply administering its courts and holding participants accountable under the law. I think if anything, this bill may address separation of powers concerns because, as you know, under the Wyoming Constitution, Wyoming Supreme Court is tasked with the administration of all inferior courts. And as we currently stand, we have an executive agency that has extensive administrative control over a treatment court. So I think this bill addresses that concern by moving control of the court to the judicial branch, but then leaving oversight, licensure, accreditation of treatment court providers with the Department of Health where it really belongs.
Follow up. Fine. Other questions? Representative Harrelson.
Thank you, Mr. Chairman. First and foremost, if I could go from a excuse to a present on the roll, that'd be awesome. And then second question, I'm gonna kind of go down that same line and I just want to be careful because I don't want to we don't want to get ourselves into a place we're not supposed to. So two things, it would be Article 2, Section 1 says the power of governments of this state are divided into three distinct departments, the legislative, executive, and judicial, and no person or collection of persons charged with the exercise of power properly belonging to one of these departments shall exercise any power properly belonging to either the other. And so I just want to make sure we're not transferring power. And then the second area is it'd be Article 5, Section 16 says no duties shall be imposed by law upon the Supreme Court or any of the judges thereof, except as are judicial. And I'm not claiming, I'm not saying, I just want to make sure because I don't want it to be a situation where we're supposed to, we're doing something inadvertently that isn't intended and breach that. Because obviously it's not our place to exchange because currently this is under the executive branch, we're moving it into the judicial branch. And so and I know we talked a little bit, but I want to drive this down this road a little further and make sure that we are not breaching these in any way.
Mr. Birmingham, separation of powers and judicial duties being imposed by the legislature.
Chairman Wassett, Representative Harrelson, certainly appreciate the concern about complying with constitutional concerns. My response would be, treatment courts are a bit of a hybrid, right? You have this treatment aspect and this judicial aspect. And I think this bill navigates that well because in treatment court context, we have executive agencies performing executive functions. So we have treatment providers overseen by the Department of Health and executive agency. The judiciary is not involved in providing treatment or overseeing treatment providers in any way. Then we have probation and parole, Department of Corrections providing supervision. Again, judicial branch isn't providing supervision. The judicial branch isn't doing anything akin to social work. What the judicial branch does is administer the court and hold participants accountable under the law, which is a core judicial function. So that's how I would respond to that concern. I'd also note that treatment courts exist in nearly all states, and in nearly all of these states, treatment courts are housed within the judicial branch. We're not the first state to deal with this issue. And other states have dealt with it and have ultimately determined that constitutionally, these are most appropriate within the judicial branch.
Further questions? Thank you. Other state agencies wishing to testify? Director Shannon, I see you back there. Any other state agencies have input on this bill? Director Shannon, if you'd introduce yourself and then tell us what you'd like us to hear about Senate File 23. Welcome.
Mr. Chairman, House Judiciary Committees, my name is Dan Shannon, Director for Department of Corrections. Just had a few brief comments. We being the Department of Corrections, certainly support our treatment courts, actually our agency would be overrun if we didn't have an alternative sentencing. We are partners with the treatment courts that includes drug court, veterans court, things of that nature. We're in 9 counties. We have 14 agents committed. We also believe that potentially going to the courts over supervision would provide some standardization within the courts. And I also want to reassure this committee that if that decision is made to transfer to the under judiciary, that we'll support in the same faction. And to answer Representative Harrelson's question as far as corrections only, I really appreciate it. And I kind of held tight Representative on page 2, line 23, the powers of the probation agents were held within the executive branch. So, yeah, Mr. Chairman, I would stand for questions.
Questions for Director Shannon? Seeing none. Any other state agencies wishing to testify? Any other interested parties wishing to testify? Please take you one at a time here. State your name and who you represent and your position.
Mr. Chairman, committee, my name is Gunnar Malm. I'm a Laramie County Commissioner and here on behalf of the Wyoming County Commissioners Association. We stand in full support of this legislation. And I just want to give you a little background as counties are the ones who administer these programs across our state. We are the ones that hire treatment court coordinators who then do the treatment piece and contract, and we approve the contracts with the local treatment providers. I personally am very passionate about these programs. I think that they are not only financially responsible and fiscally responsible, but they're a moral imperative in our communities. They really provide the opportunity to change lives, which we don't see often in the criminal justice system. And so I believe that with this move, we have the potential to see an expansion of these courts and the work that they do throughout our communities. There's at least 11 different kinds of treatment courts that are available throughout kind of the system nationally. I know that Albany County has a very successful juvenile treatment court program. Laramie County operates a veterans treatment court program. There's a host of other ones that are available that can help us kind of mitigate costs and also reform offenders and hopefully get to that root cause, which is something over 80% of our incarcerated folks, which is a substance use issue in its entirety. And so these programs really address that. And I think with the buy-in of the Supreme Court and the judges at that level, it adds credibility to the programs across the state and will allow us to operate them more effectively. And so happy to answer any questions.
Questions, Mr. Mull? Appreciate the commissioners participating this morning. Thank you.
Thank you.
Mr. Winnie.
Mr. Chairman, Bill Winnie, Sublette County. I'm here to speak for myself, but I would note for the information of the committee that I am a board member for the Wyoming Veterans Legal Assistance Foundation. The issue you're dealing with here is this purely a treatment issue or purely a legal issue or somewhere in between? And it's the somewhere in between that questions such as Representative Harrelson's thoughts get to. With regard to veterans, you see a continuum of behavior from suicide to criminal behavior. On the suicide side, a number of times you hear things like 22 veterans a day nationally are committing suicide. As you come across the continuum, you go from suicide to substance abuse to homelessness to petty crimes to serious crimes. And this is kind of trying to aim at those that have crossed the law, but are amenable to some kind of treatment. And so that's why I ended up over in where it did in the beginning, but that's also, I think I'll show you why it's very amenable to being moved over. The magistrates that work on this follow the treatment programs, and it's very legitimate for a magistrate under the judiciary to direct treatment as part of his decision. Then somebody's got to follow it, and somebody's got to make in the case I'm talking about, the veteran hold his feet to the fire and stick with the treatment. And not all do, a lot of them slide. And so you need that ability that the judiciary brings with it to direct, okay, come on, if you don't, you're going to get. And so at the end of the day, moving this to somewhere where you have the force of law of a judge as opposed to the other treatment things, I believe to be very important, and support the bill subject to your questions. Thank you.
Questions for Mr. Winnie? Seeing none, thank you for your testimony this morning. Ms. Delance.
Good morning, Mr. Chairman, members of the committee. My name is Cindy Delancey, and I'm the president of the Wyoming Business Alliance. You're probably wondering, what is the Business Alliance doing here talking about a treatment court issue? But I just wanted to kind of put it out there. People can't work if they're in jail. This is a tool to be able to help us modernize our government and to be able to be a little bit more efficient. Just a little bit about myself and my background. I am a practicing attorney. I'm a graduate of the UW College of Law. I'm also a former prosecutor, an elected prosecutor, a federal prosecutor, and a circuit court magistrate. So having been on the front lines and seeing how these treatment courts have evolved over time, I really applaud the judiciary for taking a leadership role in bringing Senate File 23 and working through the process with you as the legislative branch. This bill will provide consistency, and it's as I said, it's really a modernization effort in government. I agree wholeheartedly with my professional colleague that testified earlier in response to some of the constitutional questions brought up by Representative Haraldson, Mr. Chairman, that this actually feels like a much better fit that we're eliminating. Is this an executive function, a judicial function? You know, the treatment obviously is the executive function, but when a judge comes in the courtroom, runs the court, they really should be operating under that umbrella as the judiciary as opposed to a state agency. So for all those reasons, you know, fiscally responsible, cost saving, these treatment courts are such a wonderful tool in a toolbox to try to help people in need get the help that they're needed before they get further along in the process with either emergency detention or incarceration or Department of Family Services involved. So by able to, you know, move this forward, having consistency amongst the judiciary as well. I think the testimony was earlier that not all courts participate in this, that, you know, having that system in place that people will know what to expect in a treatment court is just really, really important as we help try to make sure that Wyoming, you know, is able to address our substance abuse and mental health needs in the future. So with that, Mr. Chairman, I'm happy to answer any questions, and thank you for hearing this bill.
Thank you for being here this morning. Any questions for Mr. Delancey? Any none? Somerville?
Thank you, Mr. Chairman. Good morning, members of the committee. My name is Andy Somerville. I'm the Executive Director for the Wyoming Association of Mental Health and Substance Abuse Centers, your community mental health centers. I am here to stand in support of this bill. Your community mental health providers provide the treatment service for 6 out of the 13 current counties. So we're heavily involved in this system. And I would note that we provide service for the smallest counties and trying to extend that reach out into our rural areas. We think these programs are incredibly important moving forward. We would certainly like to see expansion and to have them available across the state. When we began this conversation, probably a little bit more than a year ago or so, you know, I think there was some concern and some hesitancy on our part because we have been operating with the Department of Health from a provider point of view. And we certainly, you know, we have the funding that we had, and we think that it was working pretty well. What we found through these conversations is a great partner in the judicial branch. That missing that black robe effect is incredibly important. And so we think that this is a really good way to move that forward. The bill addresses our concerns about making sure that providers are held accountable by the Department of Health as well. And so we do hope that you guys will move this bill forward, and I'm happy to stand for any questions.
Thank you very much. The black robe effect, I might steal that. Questions from the committee? Thank you very much. Anyone else wishing to testify on this bill? Please come forward. Turn the microphone to the green light comes on, and then state your name and who you represent and what you'd like us to hear.
Kathy Russell, Cheyenne, Wyoming. Thank you, Mr. Chairman and members of the committee. I'm here as the guardian of a child who is affected by these rules and proposals. And that's what I will speak on. There's no question that courts should be consistent. And my understanding is that, in fact, we do have treatment courts here. And it's also my understanding that 4 courts have recently been added to the system. My concern is the repeated references to Chapter 14. There are 5 titles referenced in this bill. Title 5 is court-supported treatment programs. Title 9, administration of courts. Title 7, criminal procedure, and Title 14, children. And in fact, besides the juvenile justice component, there is a reference to children under consent decrees. And so the reference is that parents, the children of parents could be affected. And so this is where I come in. I have 16 years of experience under these rules and laws. And because of family situations, I don't think there's anyone in the state who's not affected by either drug problems within their family, with foster situations or adoptions or divorce decrees. What's not clear to me in this bill is where the differentiation will come in. My personal experience has shown that the team approach with local providers has been incredibly effective. And so right now there is a panel of experts that works with the Department of Health to put a holistic plan together for children. On page 13, lines 15 through 18, that panel is removed. I'm sorry, I referenced the wrong one. Page 15, lines 6 through 10. Those impaneled experts are removed. It's agencies, departments, individuals, staff in law enforcement, child service protection, mental and behavioral health experts who have years of education, training, and experience to address the various needs of individuals in the CSTPs, the court supervised treatment programs. Nowhere can I find that panel or members of it would again be involved. In fact, on page, I'm confused, page 14, lines 4 through 8. Except as otherwise provided, the Supreme Court shall promulgate the rules and regulations necessary to implement this act, including establishing standards consistent with the key components of drug courts, which I would assume will continue to remain that holistic approach, pulling everyone in. In my personal experience, it took that team to get the whole thing right. Right below, even though it says the Supreme Court shall promulgate rules and regulations, in lines 10 through 13, it says the Department of Health, in consultation with the Supreme Court, shall promulgate rules. That appears to be contradictory to me, but I am not an expert here and I'm not a lawyer. It's just looking at it as someone protecting a child in the system. What this bill does is it chills me, because I'm thinking if the treatment program is not working for the child I'm caring for, where do I go for redress? If the rules are all under the Supreme Court, do I go to Supreme Court to rule against the Supreme Court? I'm not sure how that works. And I'm not sure this has been addressed. It's not that I don't think that there should be consistent rules across the treatment courts. It's other aspects of this bill that have me asking questions. One of the other things that I looked at is, well, are we inventing a wheel? So I went out to look and see where else treatment courts have been put under the Supreme Court in the way that this bill does it, with promulgation of rules, of certifications, of accreditations. The only thing I could find was an article published in November of 2022 under the Justice Center of the Council of State Governments, From Treatment Courts to Supreme Court. It was the opinions of 3 Supreme Court justices in Idaho who were former treatment court judges. They participated in the treatment court system. That's the only thing I could find, and they were proposing it. So what are we going to use for a go-by? This is a very huge move and a very complicated move, it looks like from my end. I've sat in 2 committee hearings and gone through some of the materials that were provided in the interim committee, and I don't see the input from people like me. What impact will this have on your family? What impact will this have on your child? If I'm simply asking, if there are any questions in your mind, please don't pass this. Please get those questions answered that I have raised before it gets passed on, because they're big questions. Thank you.
Thank you, Ms. Russell. Appreciate the questions. On the certification and accreditation, it was my understanding from testimony, Mr. Johansson might add to this, but that pertains only to the treatment providers, that the Wyoming Department of Health would continue to be the agency that would make sure that the treatment providers were properly accredited and the facilities that were providing treatment were properly accredited. So the rules, they're not really contradictory. The rules specific to the certification and accreditation of treatment personnel would still be handled by the Department of Health, the agency with that expertise. The court would promulgate the rules of the other facets. But when it comes to treatment, we want our Department of Health, which is the expert, to make those determinations. So there really isn't a conflict in the rules. One set of rules specific to the treatment people will come out of the Department of Health. The rules pertaining to how the rest of the system functions will be determined by the judicial branch. I hope that helps put your mind at ease a little bit. I will have someone testify a little bit about Title 14 and the juvenile aspect, but appreciate you. Any other questions for our witness, Ms. Russell? Thank you very much. Representative or Director Johansson. I think you've heard the comment. Did I answer that correctly? And is there anything in here that's going to affect juvenile operations?
Mr. Chairman, again, Stephen Johansson with the Department of Health. Appreciate the previous comments, and she raises good questions and concerns that were certainly present while we discussed with this committee and internally what this transition would look like. A couple of things there. You did answer accurately that the rules will essentially be split, and that kind of memorializes how things happen now. As Mr. Birmingham mentioned, the courts handle the court business, and not to be overly facetious, but people in black robes typically don't listen to me as well as they listen to the Supreme Court or the Chief Justice. And I think that's a move that on the administration side of these programs is positive to essentially allow the Supreme Court and the judiciary to promulgate those rules. Now, to that point, I think it's fair to point out in the bill that what is now in statute with essentially how the funding works, which goes through local funding panels, and there's statutory requirements that you can see in the bill that have mandatory participation from certain folks, that doesn't necessarily go away. Again, the rulemaking authority for how the court administration happens goes to the Supreme Court in this bill. As Mr. Birmingham mentioned, and as was discussed during the interim committee meetings as well, I think the point of the next 18 months, should this pass, is to look at what the best operation for both the administration from the state level in the judiciary and that local participation in how that happens will be part of that rollout. I think giving the court the ability to promulgate those rules and go through what happens in rule promulgation with public comment, with legislative review, et cetera, is appropriate. But the concerns are absolutely well founded. These are folks who are often in vulnerable situations that have sometimes significant mental health and substance use needs. And I think we all want the same thing, which is very high quality for these services. And we've talked about that my agency will still be involved to ensure that. But it's absolutely a well-founded concern to make sure we don't lose something in terms of quality or compliance or expert participation in governing these programs, especially the treatment. And I don't see too much of that risk here. Again, I'm very comfortable with the partnership we have with the Judiciary and the Supreme Court and Chief Justice Fox on all things mental health. That we'll get this right over the next 18 months should it pass. In terms of Mr. Chairman, if I may, on the juvenile side, we in operating these court supervised treatment programs, we do have some juvenile courts that operate similar types of treatment programs for minors who have committed crimes. I'm happy to provide the committee offline that data of what adult courts and what treatment courts we have and where they are. In terms of its overlap with Title 14, I'm probably not your best expert there, but happy to answer any questions about that if I can.
Okay, very good. We're getting a little tight on time. I do want to go to Ms. Mongold online as a witness. Thank you, Mr. Johansson. Appreciate that. Ms. Butler, you might be prepared. I think we're going to talk dollars and cents next. So if you want to come up and be ready to address the fiscal note after this next question. Okay, we're not getting access to Ms. Mongold. We'll continue to try that. Ms. Butler, would you please come forward? I think the committee has a pretty good idea of what we're trying to accomplish with this bill. Would you kind of walk us through the fiscal note?
Mr. Chairman, members of the committee, my name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. So I think there are two aspects. And again, I'm sorry, I don't have the fiscal note right in front of me, but I have a general idea. So generally what this bill will do administratively and fiscally is the program will be shifted obviously from the Department of Health to the judicial branch. And that will mean that the funding that is currently under the Department of Health would come to the judiciary along with one full-time position. So as of today, the fiscal impact is net to zero. It's just taking that money out of the Department of Health and moving it into the judiciary. Mr. Chairman. The other piece of this is we have requested funding under ARPA to hire a consultant to come help us in the transition. And so that consultant will come in, we will talk with them, we'll talk with the Department of Health. And the goal is to try to make the transition from the Department of Health to the judiciary as smooth as possible and provide or present as little disruption to the programs throughout the state as we can. So, Mr. Chairman, those are the two aspects of fiscal pieces.
Thank you. And the consultant cost is separate budgetary request, not included in this bill?
Mr. Chairman, that's correct. It's under the ARPA bill.
Okay, very good. Questions for Ms. Butler? Thank you. Anyone else in the room wishing to testify on Senate File 23? Seeing none, close public comment. Committee, what's your preference? So we have Representative Nemec move.
Hello.
By Representative Crago.
Hello.
All right. Ms. Mongold, I'm sorry, we were trying to reach you a little bit ago. We're about out of time. So very briefly, tell us what you'd like us to know about Senate File 23.
Okay, thank you, Mr. Chairman. There are three provisions in our Constitution, our Wyoming State Constitution, that this bill violates. I understand how important this bill is. And I understand that people, you know, the executive branch, judicial branch would like a smooth transition. In order for this transition to be smooth and to do it right, because you only get one shot at this, is to get a special interim committee to deal with all of the ins and outs of this. And our state constitution would require to be amended. Right now, if you pass this bill, 3 violations of our state constitution will occur. And there should be no reason to just ignore such a high bar. At the very least, let's put an interim special committee in charge of this to work out all of the details. My biggest concern is the juvenile aspect in this. Perhaps you could amend out anything that has to do with Title 14, because we're getting into mental health issues with children. And as one of the other witnesses testified, one of the other citizens' testimony, there is no redress for a parent or a guardian to go to if they are not happy with what is happening with their with the juvenile that they are a parent of or guardian of. There's a lot in here that has to do with mental health care, coexisting mental disorders. Those are health issues, and those do not belong to the Supreme Court per Article 5, Section 16, per Article 2, Section 1, and per Article 1, Section 38. Parents and guardians and legal representatives of any children have the right to make healthcare decisions. That right should not be taken away and given to the Supreme Court. I really, really am asking that you look at our highest law here within our state constitution and abide by that. And if the executive and judicial branch really wants this, they need to go about this the right way and get resolutions to amend our state constitution and let citizens vote on that. Instead of just running right over the top of our state constitution, violating it, and just carrying on. That's just not the way that this is supposed to be done. We have 3 branches of government. 2 branches are ignoring our state constitution. You are the guard of this, and we really need you to honor our state constitution, and let's get this done the right way. We should not be in a hurry. And so I thank you very much for this opportunity.
Thank you, Ms. Mongold. Appreciate your comment. Any questions for Ms. Mongold? Seeing none, thank you for testifying this morning. With that, I'll close public comment. Just to add a follow-up to that, we did spend the interim. Legislative Joint Judiciary spent the interim on this topic. We have heard some legal assurances that this is a constitutional approach to a kind of a hybrid situation between the executive branch and I think we have tried our very best to carve out within the language of this bill what are the executive functions that are going to be performed by the Department of Health and the Department of Corrections, and what are the judicial functions. And so interesting questions and concerns, but we have a motion by Representative Nemec and a second by Representative Crago to move the bill. Any amendments on the bill? Discussion on the bill. Representative Chestic.
Yes, very briefly, I am in favor of the bill. I have heard these constitutional concerns. I shared some of them, but I don't think that the way we have it right now is unconstitutional. I think there's a lot of examples in the law of Article 1 courts or courts, regulatory courts that are run in the executive branch. So which is how this is running right now. So I don't think it's necessarily unconstitutional, but moving it to the court system is better. It just feels more natural to me that this is more of a judicial function, but it does, and I appreciate the earlier question about that one section that looks like it was confusing. It's not confusing. It actually is the way we make it constitutional. We separate the administration function away from the courts and put it in the Department of Health where it belongs. So I am very comfortable that this is probably a better solution than what we have right now. So I'm in favor of the bill.
Other discussion? Representative Harrelson.
Thank you, Mr. Chairman. So I have gotten quite a bit of kickback on the constitutionality of it. And so it's a question that I have is why wasn't it put in there? Why wasn't it originally placed in this direction in this way? The other thing that I kind of have a struggle with is on page 15, as it was discussed, when we take the broad stance of multiple entities having the ability to have say in something and bringing it into a narrower scope. I do struggle a little bit with that. Do I believe this is is a good thing in time, maybe so. I just struggle a little bit with kind of where it's gone and how it's gone there. So with that, I will be a no vote today. And if it goes through, I definitely want to look at the possibilities of maybe opening up that oversight a little bit.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. I have an amendment.
Okay, asked for that a minute ago, but
Oh.
present your amendment, please.
Page 15, lines 8 through 12, reinsert the stricken language that adds the panel.
There a second to the amendment? Second by Haroldson. We're on page 15, Debbie, lines 8 through 12. We're going to unstrike the stricken. We good there? Okay, committee, are we clear on what the amendment is? Discussion on the amendment. Representative Rodriguez Williams.
Thank you, Mr. Chairman. Just to piggyback on the concerns that Representative Haroldson already addressed, I'm a firm believer in collaboration, such as MDTs at the ground level, and I think that this panel is got some influential entities that come together, and I'd like to not see this go away.
Representative Oakley.
Thank you. On and against, to start piecemealing it now will get the intent of the bill and confuse things. So I don't think that's the right direction. On and against.
Representative Craigle.
Thank you, Mr. Chairman. So we worked this for the entire summer and put a lot of effort into trying to get this right. And now at the last minute, we're going to shift gears and go in a completely different direction. I guess I just don't think that's, I mean, if we want to do that, or if we were going to do that, we should have had that discussion months ago. I mean, I'm not afraid of putting it there. I mean, that's the intent of the bill, is really to transfer it over. That's the idea. And then if it's not working, we can come back and fix it if we have complaints after the fact. But I'm sorry, I wasn't here. I was over presenting one of our joint judiciary bills across the hall. And so I didn't hear testimony, I guess, from the stakeholders, you know, if any of those departments listed in there come up to the table and complained and said, we got to put it back to that. If that happened, I guess that would be a different story. I'm guessing it did not. And so I'm on and against the amendment.
Representative Chestic.
Thank you, Mr. Chairman. I'm also on against the amendment. The lawyers are unanimous on this one. But I do think that this muddies the water. The Supreme Court, you're basically saying that reinstating those lines creates a separation of powers issue. Again, the Supreme Court is either in charge or it's not. This makes it in charge, but I don't believe that the Supreme Court is going to make the decision blindly. They're going to be asking people, how should we do this? They will consult with all the groups here that are listed in the stricken out language are going to be consulted. I don't think we have to require that. We can't tell the Supreme Court what to do, but I trust our Supreme Court to do the right thing. And they're going to take input and get information from these stakeholders about how to do it. So I am very comfortable with the way it's worded. And I think in order to make it a clean bill that makes it clear that the Supreme Court has the final determination, I think we need the language the way it is.
Further discussion? Okay, all in favor of Representative Provenza's amendment? Representative Rodriguez Williams, my apologies. Representative Rodriguez Williams amendment to unstrike the stricken language on lines 8 through 12, say aye.
Aye.
Those opposed, no. No, that amendment has failed. Question on the bill. Debbie, will you call the roll?
Representative Craigle.
Aye.
Representative Chestick,
Aye.
Representative Haroldson, Representative Jennings,
Excused.
Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
Aye.
Representative Rodriguez Williams,
No.
and Chairman Waschit.
Aye.
There's 6 ayes and 2 noes and 1 excused.
6 ayes. Bill has passed House Judiciary. Do I have a volunteer to carry the bill on the floor?
I'm happy to do so.
Representative Craigo, very good.